All right. Good afternoon, everybody. My name is Stephanie Goldstein. Welcome. Here we go. I'm just seeing everybody come in. I hope everyone can hear me clearly, and I hope everyone can see me. You're welcome to keep off your videos and your audio. If you have any questions, you're welcome to use the chat box and submit them. I'll do my best to answer questions at the end of this presentation. And if I'm unable to answer questions, you can always continue to submit them to us in the chat or online, and we can do our best to get back to you, or we can schedule a consult. All right, so welcome everybody. We are gathered here today to discuss Article 81 guardianships, specifically the process in getting started with an Article 1 guardianship. I'm not going to include a discussion about the hearing itself, just the process of getting started, because it can be involved and a little bit confusing, and I'll do my best to kind of clarify the basics of an Article 81 guardianship proceeding. Now, there may come a point when you or someone you know knows an elderly person who is experiencing some sort of decline, some sort of cognitive decline, and is no longer able to manage his or her affairs. And those affairs would be paying bills, banking, going to the grocery store, ordering groceries online, ordering things online, or ordering too many things online, and just taking care of that person's day-to-day activities, walking, grooming, brushing their teeth, those sort of things. If that particular person was diagnosed with some sort of illness or suffered a stroke and is experiencing symptoms of dementia and or Alzheimer's, and those signs would be memory loss, confusion, forgetfulness, overall cognitive decline, and potentially not realizing that person is experiencing that cognitive decline. It may be time to consider a guardianship for that person. And there are two types of guardianships generally in New York. The first is under under 17A of the Surrogates Court Procedure Act, which would be for someone who's intellectually or developmentally disabled. And what I mean when I say intellectually, sometimes it could be that person sustained some brain trauma that has impacted that person. And the other guardianship I'm talking about would be Article 81 under the Mental Health and Mental Hygiene Law. And that's the proceeding that I'm going to be talking about today. Sometimes they can be a bit confused, so I hope this can clarify. Now, the person who will be the subject of an Article 81 proceeding would be someone who's allegedly incapacitated. That person will be known during an Article 81 proceeding as an alleged incapacitated person, or an AIP. So if you hear me saying AIP or alleged incapacitated person, that's who I'm referring to. That person who's in need or may be in need of a guardian due to some sort of cognitive decline. Now, just a little bit of background about Article 81. The New York legislature enacted it to tailor it specifically to meet specific needs of that person. The court would take into account preferences of that person, desires, and personal wishes. The goal of Article 81 is to afford that person with the greatest amount of deference and independence. It's intended to be the least restrictive means of intervention. And having said that, there are two types of guardians within those types of guardianships. There's the guardian of the person, and there's the guardian of the property. You may hear me talking about guardian the person and guardian of personal needs. It's the same thing. They're interchangeable in this respect. And when there's the guardian of the property, you may also hear me say guardian of property management, guardian of property affairs. They're interchangeable in this respect. The guardian of the person will be taking care of a person's living needs, grooming, making sure that person's eating, making sure that person is meeting his or her doctor's appointments, and scheduling those appointments, ensuring that that person has dental appointments and going to the dentist, making sure that person has care, can take care of it, has somebody take care of that person. And the guardian of the property is somebody who's looking after the AIP's needs, property needs, banking, paying bills. If the person, the AIP, Is it a property owner, making sure that rent gets collected, making sure that income tax returns are filed. If the person is in need of Medicaid or any other government benefits, the guardian of the property would be responsible for applying for government benefits, those sorts of things. All right, so what you really want to consider before commencing a guardianship proceeding is a guardianship should be the last resort. So you want to consider whether it's necessary and whether that person has an estate plan in place. Now, when I'm talking about estate plan, I'm talking about advance directives. And those advance directives could be a power of attorney, a healthcare proxy, nomination of guardian, and a living will. I also could be talking about irrevocable trust. Now, these sorts of things have been discussed in prior webinars. We're welcome to talk about it today. If you have any questions, I can do my best to answer them. The goal is to sort of tailor this presentation to guardianships, but just to give a little bit of background, if a person does not have an estate plan in place, which would include a revocable trust or those advance directives that I mentioned, it may be appropriate for that person to have a guardian appointed. Now, with a power of attorney, just a little bit of background, little basic stuff. The power of attorney is that legal document that allows your agent who you appoint to manage your financial affairs. So remember I talked about the guardian of the property. An agent acting under a power of attorney can have similar authority. The power to file tax returns, should the document allow it. The power to engage in banking, should the document allow it. The power to pay bills, should the document allow for it. Now, when I talked about the guardian of the person or the guardian of the personal needs, the advance directives parallel to that would be the healthcare proxy. Now, that's a legal document that allows the agent to make healthcare decisions on behalf of the person. Should those documents not be enough, not provide the agent with enough authority to act in the best interests of the AIP or the ward or the person who they're acting on behalf, a guardianship may be necessary. Okay, just moving on. Now, once you've decided that a guardianship is the most necessary thing to do, you want to consider who to be the petitioner. Now remember, it's a petition. So the person who thinks the guardian is necessary needs to think of whether that person wants to be the guardian or has someone in mind to act as the guardian. And even before then, we need to consider where to file the petition. Now, an Article 81 guardianship matter is to be filed in the Supreme Court of the county where the AIP, that alleged incapacitated person, resides. So if the person resides in Westchester County, but you, the petitioner, reside in New York City, you would have to file the petition in the Supreme Court of Westchester County. Now, in your petition, you're asking for certain relief. So you're asking for a guardian to be appointed. So you need to consider what guardian you're wanting to be appointed for this person. Are you looking for a guardian of the person to be appointed, a guardian of the property to be appointed, or both? Oftentimes that's the case. Now, Article 81 sets forth who can be the petitioner. The AIP can be the petitioner. The AIP sometimes can realize they're in need of help, and a guardian is just the person who can provide that help. The next would be next of kin, a parent, a sibling, or even a spouse. Sometimes it would be if the person is living in a nursing home facility, it could be the facility that would file the petition. Those are the types of individuals or people who could file a petition. Now, there are several documents that must be filed in the courts to commence an Article 81 proceeding. The first is, I mentioned, the petition. And the second would be an order to show cause. So let's just back up and go to the petition. The petition is what really gets into why a guardianship proceeding is necessary. So first you list who the petitioner is. It could be mom, dad of someone who's in need of help. It could be a daughter. Let's say the daughter is the petitioner. The daughter will say, I'm so-and-so, I reside X, here is my telephone information. The AIP is my father, my brother, my sister, and here is that person's contact information. And the petition will also state the relationship between the petitioner and the AIP. There could be co-petitioners that apply for guardianship of a person. There could be more than two people that apply. After stating that basic information, that personal information, you want to get into why a guardianship is necessary. So if a guardian of a person, you think it needs to be appointed, you get into why. So if the person needs help grooming, needs help brushing teeth, needs help to get to the doctor's appointments, unable to transport him or herself, you'd explain why. If the person is in need of a property guardian, you would talk about what resources you believe that person to have. And if that person has been paying bills, if you knew that that person wasn't paying bills, you would say this person hasn't been paying bills, they're in default. If this person lives in an apartment and isn't paying rent, you can say this person is not paying rent and could be at risk of eviction. The purpose of the petition is to set forth why a hearing on an article of guardianship proceeding should be heard. So it needs to be give enough information for the judge upon reading the petition to then look to the order to show cause. Now the order to show cause will lay out general information. It will not be nearly as specific, if at all, of the petition. It will say this person has filed a petition seeking an Article 81 guardianship proceeding to commence. Here are the powers that the petitioner seeks for the guardian to have. Whether a temporary guardian is necessary according to the petitioner, whether a temporary guardian of the person or a temporary guardian of the property or both is needed, and what powers specifically those guardians should have. And if the court deemed that the petition was enough to get an Article 81 proceeding started, the order to show cause will then lay out when and where. Now, before this pandemic, unfortunately, all hearings were to be held in person. And since the pandemic, hearings and/or conferences with the court have been held virtually. So the order to show cause will state whether the hearing is to be in person or virtual. Now, how does someone know how to appear virtually? I'll get to that. But first, let me get to what else needs to be laid out in the order to show cause. Now, once the court determines that a hearing is to be held, the court will then specify who needs to be served and what papers need to be served. In addition, the court will determine whether a court evaluator should be appointed and an attorney for the AIP should be appointed. Sometimes one or the other, sometimes both are appointed. It depends on the specific circumstances laid out in the petition. Always, the AIP must be served personally, and there is a time limit, typically within 3 days of the judge signing the order to show cause. That's your time frame. And again, must be personal service. The person must be hand-delivered the documents. If there's a court evaluator appointed, and I'll get to who that is in a moment, that person will likely need to receive papers by mail, overnight mail, by email. If the attorneys have a relationship with this person, they know who they are, or if the judge provides it in the order to show cause. And the same thing with an attorney for the AIP. That person will also need to be served, most likely overnight mail or email if it's someone that the attorneys know, or the judge provides that email address. Now, in addition to the order to show cause and the petition that were filed with the court, there's an additional document that needs to be served on the AIP, the court evaluator if appointed, and the court-appointed attorney for the AIP if appointed. So there's the order to show cause and the petition, and there's something called a notice of proceeding. And that's just a general basic topic. The order to show cause would be longer as it expresses what specific powers the petitioner is seeking for the guardian to be appointed with. And the notice of proceeding just says a petition was filed by somebody seeking a guardian to be appointed for the AIP and when it is. It also provides contact information for the attorney for the petitioner. So if it's virtual, a person who would like to appear can then contact the attorney. The court evaluator can contact the attorney to figure out how to get access to the virtual hearing. Now, what's been typically done is the courts will have a link for Skype for Business that they would circulate to the attorney for the petitioner, who would then circulate it to those, the court evaluator and the court-appointed counsel for them to appear. Okay, so the AIP, just to recap, and the court evaluator and the court-appointed counsel, if those two are appointed, they receive the order to show cause, the notice of proceeding, and the petition. Now, if there were any exhibits to the petition, such as a power of attorney, a healthcare proxy, a nomination of guardian, those would also be included with the petition, and those 3 documents would be served on the AIP, the court-appointed counsel, and the court evaluator. There are also those that are called interested parties. Say that the daughter of dad is seeking to be the guardian of her father. And mom is still living. Mom is somebody who would need to be served. If that person had children, those children would need to be served. And those interested parties would have an opportunity to appear at the virtual or in-person hearing. What they would receive would be 2 documents. It would be the order to show cause, which lays out exactly what's being sought, but doesn't give any facts about the petition, the specific circumstances, but just that a hearing has been commenced. And they would get the notice of proceeding. So they would get 1 less document. And again, this notice of proceeding would allow those interested parties to contact the attorney to say, hey, how do I get access to a virtual conference? I see here that it's virtual. How do I do that? And that's how you would do that. Just looking back in my notes just to kind of keep things going. Now, typically, what is required by the statute is the hearing to be held within 28 days of the signing of the order to show cause. However, due to the pandemic, this certainly during the stay-at-home procedures that were in place, that did not happen. Hearings were adjourned for months. What is happening now is courts are trying to do their best to hold them within 20 days, but it may not happen within 20 days. Just looking at my time. Okay. All right. Now, once you've served everybody the appropriate papers, there will be time for some investigation. And that investigation is to be conducted by the court evaluator. This person has the role of acting as the eyes and ears of the court. This person will review the order to show cause, the notice of proceeding, and the petition with any exhibits if attached. This person will then interview the petitioner or will interview the AIP first. Regardless, there must be interviews conducted. Now, if there is a cross petitioner, someone who would like to contest the petition seeking guardianship, that person would need to be interviewed. If there are any individuals listed in the petition or any individuals the petitioner thinks would be able to provide helpful information to the court evaluator, the court evaluator will want to speak to that person. What's going to happen is the court evaluator is preparing a report, and that report is going to the judge. And the judge will rely upon that report to have an idea as to what's going on before having the hearing. The court wants to have as productive of a hearing as possible, so the court wants to make sure that the court evaluator has enough information to have prepared a report and come to some sort of conclusion. And that conclusion can be whether a guardian is necessary, whether a guardian of a property, or excuse me, let me back up, whether a guardian is necessary for, excuse me, let me back up again, whether this person is incapacitated. Remember, you can't have a guardian appointed unless that person is actually incapacitated. So if a court evaluator deems this person to be incapacitated, the court evaluator will then determine whether a guardian person is needed, whether a guardian of the property is needed, or both. Just checking my notes to see if I missed anything. Just kind of running through the basics as quickly as possible, just to keep within the time frame. Again, if anybody has questions, you're welcome to enter the chat. Okay. I do have one question here. This is from Mary. If I am applying for guardianship and live in Putnam County, but the person I'm applying for lives in Westchester County, which county do I apply in? Great question. Mentioned this earlier. It would be the Westchester County, the county where the AIP resides. And that would be in the Supreme Court if you were considering an Article 81 guardianship proceeding, and if the person is an allegedly incapacitated person. Just checking to see if there's any questions. if you have the power, this is from Lois, if you have the powers and help documents already, what extra help does the guardianship provide? Okay, so for example, a healthcare proxy. Let's say that the alleged incapacitated person, the AIP, needs to be in a nursing home, but the healthcare proxy document does not allow for that power, but the AIP is in need of entering into a nursing home. This is something a petition could allege. That a guardianship is needed as this person is incapacitated. A guardianship of the person and property are necessary as the healthcare proxy and or any other documents are not enough. They don't have enough teeth, enough authority to provide the agent to act in the best interest on behalf of their person. There are times when there are documents in place, such as a healthcare proxy or a power of attorney, and the petitioner still thinks they're not enough. A court may disagree and think, well, the healthcare proxy is enough. Someone else is acting as agent under the healthcare proxy, and this person has been doing a fine job acting on behalf of the ward or the principal or the person who's alleged to be incapacitated. And the court would not invalidate the document and not appoint a guardian of the person in that respect. Okay. Just taking a look. Okay, this is from Felicia. If you already have a power of attorney, is a guardianship really needed? Okay, so right. So if there is such a document in place, you want to determine whether that document gives you enough power. Sometimes power attorneys don't give their agents enough teeth, enough authority to act on behalf of that person. So for example, this likely wouldn't happen, but as an example, the power of attorney does not allow the agent to bank on behalf of the ward. You would file a guardianship petition for a guardian of the property to be appointed to allow banking on behalf of the person. So again, if there are documents in place and they are providing enough authority to their agents to act on behalf of their person, then a guardianship wouldn't be needed. Okay, this is from Thomas. Would a stroke count as brain trauma under 17A? Would 81 be better? That is something that's a very good question, Thomas. Article 81 is generally for someone who is incapacitated due to some sort of cognitive decline. So if a stroke has caused that person to experience a cognitive decline, that the Article 81 avenue may be the best avenue. If you have further questions about those kind of case-specific facts, you're welcome to reach out to us after this presentation. You're welcome to come in for a consultation as well. We can sit down with you or we can do a Zoom to talk about the specifics and whether an 81 guardianship matter is appropriate or whether a 17A guardianship is appropriate. That'll be a presentation for a different time. We can also talk about whether a guardianship is even needed. Okay, I'm just going through the chat. Okay, one thing I wanted to mention is whether you think a person is in need of taking medication. A guardianship in New York does not have that power, does not allow for that power. If a nursing home is the appropriate facility for your alleged incapacitated person, or if an assisted living facility is the best environment for your person, and the healthcare proxy that's in place doesn't allow to select that person's place of abode, a guardianship may be necessary. If that person is experiencing difficulty and not catching on to scammers, if that person is having difficulty paying bills, that would be the appropriate set of facts to see whether a guardianship of the property is necessary if a power of attorney document is not in place. Okay, if someone else is taking care of the child, can another person become the guardian? Do you need to go to the judge when older adult is ill and now need younger adult to have guardianship? Okay, if a person is incapacitated, now generally Article 81 is not necessarily for a child under 18. I'm not sure if that question was considering that. It's generally for an elderly person who's experiencing some sort of cognitive decline. This person used to do a fabulous job of managing his or her own finances, and it's obvious to a petitioner that they're no longer capable of doing that, and a guardian is appointed. That guardian may not want to act in that role or be unable to maintain that role. And a successor guardian can be appointed, or a successor can be appointed. And you would just need to file a petition to explain why you're seeking to resign as guardian or have it discharge this particular guardian, and a successor guardian should be appointed. Okay, if AIP family feels guardianship is needed, great. So if the AIP is on board and is aware, that's one of the factors to consider whether guardianship is needed. This person is aware that he or she is in cognitive decline. That would be very helpful to explain the petition that the AIP is aware that he or she is in cognitive decline. The court evaluator, if appointed, would still investigate and would still reach out to the AIP and determine whether the AIP feels that a guardian should be appointed. And the AIP can certainly say whether incapacitated or not, yes, I want a guardian, or no, I don't need a guardian. And the court evaluator would make a determination for the court whether one should be appointed. Okay. Person property can stuff. Okay. If there is a cross petition seeking to not have a guardian appointed, or the petitioner who's if the petitioner is seeking to be appointed as guardian and a cross petition says that person is not the appropriate person to act as guardian, the court evaluator would interview the cross petitioner and get a feel for why the cross petitioner doesn't want the petitioner to become guardian. And the court will take into account the report. The court will hear testimony at the hearing. Again, the hearing is the subject of another presentation, so I can get to that on another date. But the court would determine whether either petitioner or cross petitioner or another cross petitioner is really a good fit for the guardian, and the court may even appoint an independent guardian. And it could be an independent guardian of the person, an independent guardian of the property. It could be the same person, or it could be two different people. The court wants to think about what's in the best interest of the AIP. What is the AIP's preference? And the court will also consider avoiding family strife and determining how best to go about that. Just taking a look at the comments at the chat to see if there are any further questions. I'm also just looking at my notes. Oh, okay. And just thought of this, I apologize. This is not an article, 17A guardianship presentation, but just for any questions that may be lingering in people's heads about 17A, a child must have been deemed disabled before the age of 22. So this proceeding that I'm talking about, it's someone who is well past 22. Taking a look, just bear with me. Again, if anybody thinks of a question after this presentation, you're welcome to reach out to us. You can also Look at our website at littmankrooks.com for any further information about Article 81 guardianships. We also have information about 17A guardianships. You're also welcome to meet with us and come in for a consultation, or we're happy to do a Zoom conference to meet with you. And with respect to Article 17A guardianships, Amy O'Hara is actually going to be presenting on that very specific topic in a couple weeks. So I hope you'll all join us then. I'd like to thank everybody very much for joining us today. If there are no further questions, I would like to bid everyone a lovely day, and we hope to see you again. Thank you very much, everybody.